Supreme Court of Appeal is expected to hand down its ruling on the legality of former President Jacob Zuma's medical parole on Monday. It will also decide whether the High Court was correct to find that the time spent by Zuma on medical parole should not count as part of his sentence. I'm joined now by legal analyst Benedict Phiri. Benedict, thank you for making time. How significant is this judgment in the Supreme Court of Appeal tomorrow, given that the former president has now actually officially been released on parole?
I think it's a very significant judgment because, if you just recall the decision of the High Court, the matter concerns an unlawful exercise of power by Arthur Fraser, which implicates or rather seemed to undermine the constitutional court order which sent Mr. Zuma to prison. So it is a significant judgment because it deals on aspects relating to the rule of law and equality before the law, as well as the respect for the judiciary and the respect for the orders and the judgments that the courts make.
Mm-hmm. What arguments did Zuma's legal team advance when they were trying to appeal that High Court ruling in the SCA?
Zuma's legal team essentially made the argument that Arthur Fraser was empowered to overrule the Medical Parole Advisory Board, and also, assuming that, he was properly empowered to do so, he took the relevant considerations into account, meaning that he took Dr. Mafe's medical report as an indication that Dr. Zuma was eligible for medical parole. Obviously, the Helen Suzman Foundation and the DA argued the opposite, to say the Correctional Services Act did not empower Arthur Fraser to make that decision, and also he took irrelevant considerations. You'll recall that some of the reasons that Arthur Fraser gave was the risk of unrest, the fact that Mr. Zuma was old, etc., which were not reasons to be taken into consideration in the granting of medical parole. So from my perspective, I think, there will be no question around the unlawfulness of Arthur Fraser's decision to put Mr. Zuma on medical parole. I think it's pretty clear that the Act does not give him that power. And even if you could construe it as giving him that power, he took irrelevant considerations which are grounds for unlawfulness. Really, the question is then, what is meant to be the just and equitable order that the court should give in these particular circumstances? And I think you'll see a detailed exposition tomorrow relating to what would be just and equitable in this particular instance.
Yeah, and I think a lot of clarity as well around whether or not the Commission of the Correctional Services the department can override the Medical Parole Advisory Board's recommendation. And I wonder because I remember Justice Nambita Dambuza asked some really critical probing questions around the advisory board, and she asked why members of parliament would make these lengthy efforts to establish statutory bodies like the Medical Parole Advisory Board only for the commissioner to disregard its decisions, because it was the appeals board that ruled there were no grounds to release Zuma on medical parole, and for some reason Arthur Fraser, as commissioner, felt I can actually override that. I can consider the report and then still make my own decision.
Yeah, and I think that is a necessary clarity because you will recall that these amendments to the Correctional Services Act came about as a result of abuses of the medical parole system and gaming the system that we know some of the high-profile cases like Shabir Sheikh that occurred in the past. So, Parliament put this Medical Parole Advisory Board for that very reason, so that there would be no further abuses and that the question of whether a person was terminally ill or was so physically incapacitated that, he needed to be released outside of the prison system, it needed to be made by a board comprising medical specialists who would consider all the relevant reports that would be necessary into making that decision. And that decision is actually made on majority by that particular board. And one of the doctors that actually examined Mr. Zuma was part of that particular board. And, even though his view was in the minority, the majority held. So if you take into context the history of the legislation and what it is intended to do, what Arthur Fraser did is actually set us back many years and put us back into a system which can be gamed by those that have the ability to game it. And I think, for that reason, I think the court will confirm the decision of the High Court that decision around medical parole, and specifically the question of terminal illness and physical incapacity, sits with the Medical Parole Advisory Board and is not something that a commissioner can simply just override.
Yeah, because at the end of the day, the Correctional Services Act is quite clear in that because that's what it requires. It requires that only terminally ill or physically incapacitated people be considered for that kind of parole. And the former president's team is still argued that this is a person who has terminal illness which carries a significant risk to his life, even though when you look at the latest developments around the former president, it's appearing he's doing much better, right? He's even getting himself ready to run for positions in the ANC.
Yeah, and I think that is concerning, and I think that will be a concern for what the Supreme Court of Appeal has to do once it finds that Arthur Fraser's decision was unlawful, because, in crafting a just and equitable remedy, they essentially have to take weigh three considerations or factors. And the first will be, firstly, whether they can send this decision back to the commissioner. And we know that it's a foregone conclusion. The new commissioner has said he would make the same decision. And secondly, the commissioner can't even make that decision because of, the legislation doesn't empower him to do so. The second will be a consideration around fairness to Mr. Zuma himself and whether, it can be said that he's meaningfully served his sentence, even though he wasn't in incarceration. And I think the third one, which is really, for me, the most important, will be, the implication on the Constitution and the rule of law itself. And I think here the court will have to weigh two things. First, it will be that there is a constitutional court order that sent Mr. Zuma, to jail and said he must be incarcerated for 15 months. And effectively what Arthur Fraser did was to undermine that and really put the cat amongst the pigeons around questions around equality before the law, the rule of law, supremacy of the Constitution, etc. And the second is also, the medical parole scheme, which you're alluding to, that the legislature went to lengths to put this entire scheme so that we could have a lawful and fair and equitable regime around medical parole, which is being undermined here. So, that will be the interesting part of the order tomorrow, because the court will weigh all of those factors up in determining whether Mr. Zuma goes back to jail, or, it's considered that he's actually served his sentence and finished it, and what will the implication, and how does that leave questions on the rule of law?
Yeah. So, lastly then, tomorrow, when the Supreme Court of Appeal presents that judgment, what do you think would be the consequence on the part of the former president if the CSA actually upholds the decision of the High Court? Because the question here, is when the former president was serving part of that jail term from home after being released on medical parole, if it's found that that decision was irrational indeed, do you see the former president being sent back to finish off? Because that was the contentious issue, right? Whether should we even count, what he was able to serve while he was on medical parole?
It's really, really hard to predict what the Supreme Court of Appeal will do in this particular instance. But I would think, a pragmatic solution that gives effect to the rule of law would probably see the Supreme Court of Appeal sending him back to jail, because he would be eligible to apply for parole anyway. Yeah. So, if he went back to jail, I have no doubt that he'd apply for parole immediately on the granting of that order and judgment tomorrow. So from my perspective, that would probably be the most pragmatic solution, which would uphold the rule of law. But, it is very difficult to assess it is quite a complex matter, and I really can't predict what will happen tomorrow.
Yeah, listen, none of us can, and we'll wait to hear that guidance from the Supreme Court of Appeals. Thank you for making time for us, Benedict Phiri, live to us here on Newsfeed PM.